Well, good afternoon and welcome. Welcome to another Webinar Wednesday hosted by the California State University Bakersfield Small Business Development Center. Good afternoon, I'm Kelly Bearden. I am the director of the CSU SBDC, using acronyms, and I am your host for today on Managing Your Small Business Beyond the Pandemic, webinar number 114. Got a great topic again. HR, and these days, there's always something to talk about. Being in the state of California, being in the United States, being on Earth, there's always some great HR stuff to talk about. So let's get going. So what is up on May 18th? On May 18th, 2022, well, obviously there's a lot up. And we're going to debut a new little segment here called the Economic Corner. What we've learned is last week with all of the pressing economic data, we'll just give you a few kibbles and bits of what's happening in the economic world and how the general economic really focuses and how the latest economic news is going to impact your particular business. Got a great dose of it last week with Dr. Mark Evans, Professor Emeritus at CSU. But also, we've also seen since then a number of items that have hit the news in this last few days. So we're going to do Economic Corner. And it's kind of funny, when I was talking Saturday night, I was at our School of Business and Public Administration's Student Honor Awards dinner. Very, very fun event to recognize our brightest students across all of our areas of marketing and management, and our MBA and MPA students, also the econ students and finance and accounting, and of course our SBDC student intern was also honored. But I was talking to some economists there that night on Saturday night, and I said, it's a great time to be an economist, isn't it? And they tried to convince me it's a great time to be an economist all the time. I don't know if I'm buying that, but it sounded like a good way to bust into our Economic Corner debut. And so what is happening since our update from last week? Well, inflation in the UK and the United Kingdom hit a 40-year high, coming in a little over 9% annualized. So the government there is trying to do some things, as we see throughout areas of the world. We see the Western world. We see also Germany and France and some other Western countries throughout Europe that are facing high unemployment and higher unemployment, like the US. So the inflation is staying there. Even in areas like Pakistan, where flour went up over 70%. So inflation is becoming a worldwide phenomenon. Yesterday, we had a major bank, Wells Fargo, their CEO, come out and say that the US economy is headed for a downturn. With the Federal Reserve, we talked a little bit about them raising rates twice last week. And we had their CEO, Mr. Scharf, also known as Charlie Scharf, come out and say it's going to be hard to avoid some type of recession. So one of the big players in the finance sector around the world is coming out and saying some kind of recession is imminent. Some other things that are happening around the world. We saw some really good numbers come out earlier this week, but they aren't so good on the stock market. And of course, the stock market is down, last I checked, about 1,000 points today. So we're seeing a major sell-off, and there's a major areas that are going on, and the stock market affects the economy in so many ways. Of course, the stock market is said to be the leading indicator because it's people's money that is actually leading everything. And so when the stock market goes south, it is an indication that at least investors think everything is going to be going south. So we'll continue to watch the market, but as it continues to dip into far lower terms than we've seen most of this year. So, but one person who isn't selling is a little gentleman in Nebraska. So we'll keep an eye on that and see what is going on with Warren Buffett and see if he continues to buy and if he fights the trend and what happens there. So a few weeks ago, on some other news that isn't economic, we were very concerned about ransomware and ransomware striking at the start of the Ukraine war. And actually, the U.S. has seen a decline in Russian ransomware strikes. It's not an easy thing to say. So at the start of the war in Ukraine, when they invaded Ukraine, a lot of experts thought that many U.S. organizations that were benefiting, but a lot of that ransomware and a lot of that hacking has been going on with Russian companies, with companies inside Ukraine, and other reasons is why they say potentially it is actually down in the recent months since that invasion. So that's some interesting ideas. Maybe some questions I can start asking for our guest later. If I take a remote job, can I be forced into an office? Interesting. But if you have questions today, we're going to want you to go to the question and answer box. We're going to be using the chat box a little bit today for some of your input, in addition to our polls. So we do have our HR expert in today. We have Celeste Young-Ramos, and excited to have her back and have her talk about the very latest and some of the changes and some of the mandates that are happening in California and some of the other unique things that are happening in personnel and with employees and in that human resource area. We'll give you our quick update on the open pandemic programs. Again, with your questions, put those in the Q&A box. We'll take those at the end of Celeste's presentation. We'll be putting a lot of other stuff in the chat box, and we will have a very brief poll that is somehow going to be tied to HR. We know that. So let's go with kind of a funky question today and tied to HR, and it's about our California Employment Development Department, EDD. Most of you, I'm sure, are familiar with EDD. And they have come out with a ruling for some agricultural activities demanding that employees be paid on a wage rather than a traditionally monthly salary. So our first question is going to be, which agricultural activity can no longer be paid with a monthly salary, room and board, but now needs to be paid on an actual salary, hourly salary, which will include, 24 hours a day where they will be working. A little bit of a hint there. So which activity? Will it be goat and cattle herding? Will it be egg gatherers, or will it be rodeo clowns? So EDD is saying that this activity is they're required to be on call basically 24 hours a day. They need to be paid 24 hours a day rather than taking a monthly salary with room and board, which has been the historic norm. Is it goat and cattle herding? Is it egg gathering, or is it rodeo clowns? So we do have already 59% of you in, and we are working toward getting over that 60% number. So which agricultural activity is EDD requiring to be paid an hourly wage, which would be 24 hours per day? Is it goat and cattle herding? Is it egg gatherers, or is it rodeo clowns? Okay. We have 66% of you in. Thank you for participating. What we're going to do is we're going to end the poll at this time. And what we're going to do is share the results. And sharing the results, you think it's goat and cattle herding, with 77% of you in. 23% say egg gatherings, no takers on the rodeo clowns today. So you are correct, 77% of you at least, with the goat and cattle herding. So with that, we do see that goat and cattle herders, 77%, and yes, that is the correct answer. And a little follow-up question to that. Our second question on that is going to be a follow-up. So now that we know, if you're a goat or cattle herder, you need to be paid according to the state 24 hours per day that you are working. So if that is the case, we'll launch the second part of it. Your annual wage would go from around $30,000 to, is it $73,999? Is it $167,000 or is it $554,000? So if you were the nice little goat herder making, we'll use goat herder in this example, maybe a sheep herder making, actually sheep herders are exempt from that. It's only goat and cattle. But if you were making $30,000 a year and you were getting room and board and you were content with that pay, but the state comes in and says, now, you really should be paid the full amount since you are basically working or on call that whole time. Got to think you got to sleep sometime, but maybe I'm wrong. So is it $73,999? Is it $167,000 or $554,000? So nobody's fallen for my $554,000. And yes, that is not going to be the correct answer. And we do have 62% of you in at this time, and we're going to end the poll. So last chance to get in, and we are closed at 65% of you in. We're going to share the results, and 52% of you are correct. It is 167,000. And that reduces it down to it's 48% of you thought, gee, it should be fair if we give them 73,999, and 0 actually bought the huge amount of $554,000. So thank you for participating. Just one of the quirks in HR law that we see and some of the unique things that happen. And so there. So our key relief programs. But before I go to our key relief, I just, just to show you a little bit more is, how much I like crowdfunding, and there's a GoFundMe account now to save California's goats. And they've raised about $2,700 of $50,000. And it tells the flight in this crowdfunding campaign about, the severe drought that California has. And actually, most of the goats used for this purposes are used to actually clear brush, timber, and also grasses that are fire danger. And I know this for a fact, actually, in my previous life as a chairman of a fire safe council. And we used goats, and they eat everything. They eat manzanita, which is the hardest doggone thing in the world. And they would clear out an entire area. And so there it is right there. And if you want to donate, it's put on by a gentleman in Dixon, California, kind of a smaller community. I like to say between Sacramento and the Bay Area. But there you go. Can't make this stuff up, can I? So enough on goats for today. So some of the stuff going on with our key pandemic relief programs. Our California Dream Fund program is open. You can email your interest to the CASBDC at ucmerced.edu. Some of our training cohorts, as they're called, are started and going on now. And the program will probably be going on for quite a few months to come. So there's still plenty of time to get in for at least the training, the free consulting, the business plan assistance. The funding is somewhat limited, so you're going to want to act as soon as possible on that. The Kern County Micro Grant Program remains open, time and money. The Mono County Grant Forgivable Loan Program remains open. And if you are in Mono County, I believe exclusive of the Mammoth Lakes area, you can see either Jeff Simpson or Jeff Lucas. We're closed as far as EIDL goes. EIDL is closed. PPP is closed. Forgiveness is open and will be open for another 10 months from the end of the covered period. We also have restaurant revitalization probably not coming back. Also, the City of Bakersfield Restart to Loan program is closed, but your employee retention credit is still open, and it's still open retroactively. And a couple of weeks ago, we had a presentation on it and being kind of an observation that we're seeing that many people that are able to take that particular credit are not doing so. So again, there's what we have on the California Dream Fund. That's for new entrepreneurs, $35 million coming out of the Small Business Advocates Office of the state of California. through GoBiz. And the Dream Fund program is a $35 million program statewide. Again, it's to provide training, business plan consulting, and also assistance in getting a business plan and potentially grants, $5,000 to $10,000 for those wanting to start. The Kern County Micro Grant Program, grants of $2,500 are open. We're seeing declines in these areas. If you received a California relief grant, you're not going to receive this micro grant. If your sales, not your net income, but your sales exceeded $50,000 in 2019, you're not going to get this. Also, if your micro program, your micro business was not your major source of income. So if you had a job that paid you more money than your micro business, you're not going to get it. And there's also some other eligibility issues. So there have been changes to the program. The latest update is, I believe the first round of checks are going out right now. It has been delayed with some changes that were mandated from the state and flowed down to the county, and then we got to get them back out to the clients, get more additional information. So hopefully we're going all the right direction right now. We'll be talking a lot about this $1.1 billion it's only a $900 million program now. Changes actually have the U.S. Treasury sending $900 million instead of $1.1 billion. We'll talk about a lot of these new loan programs and some of the venture capital that might be associated with these particular areas. But let's bring in our special guest now. Very happy to have Celeste Young-Ramos back with us. She is the founder of the Restaurant Success Center, has a great background. I was going to tell you a little bit of a story, but I ran out of time where she spent over 20 years, Celeste did, with human resources at Denny's. I did try to go to Denny's on my birthday and get a actual free breakfast. It didn't work out for me. So sorry, Celeste. I did try for my free breakfast. And then I tried to get coffee at Starbucks, and that didn't go so well either. But, fun before 6 o'clock in the morning on Buck Owens Boulevard. What can I say? So Celeste has several clients that include several chain operations, independent. At Denny's, she worked over 20 years experience as their human resource manager and franchise director, giving her multiple talents, both in the restaurant HR area and also in assisting you and helping your restaurant succeed. So Celeste is a graduate of Brigham Young University. Great to have you, Celeste. Come back in here and take it away from me. Thank you so much.
Well, thank you, Kelly. And I have to say, since you started out with a goat story, I actually grew up on a goat farm in Dixon, California, and had to milk 50 goats every morning with my family before school. So that goat herding job looks kind of attractive to me. So I think I would have to look into that. All right, so let's see here. Let me get my slides up for you guys today. Welcome, everybody. We've got a lot to report and go over today. As we go through, if you want to put questions in the chat, I'll be glad to answer those if time permits. And today we're going to go over some HR updates in the COVID-19 workplace, which, before we were post-COVID, and COVID just keeps continuing. So I think we're probably going to be facing that for a while. As Kelly said, I am a restaurant advisor and human resources advisor, and I'm certified here in the state of California. And today's topics, I wanted to go over a few things that have been in place for a while, but seemed when I go do audits at different locations, I'm finding that people don't have very good knowledge at them. And I think not having good knowledge in these areas can become quite costly to you later. And I also want to share with you some new laws that have come about this past year, things that you may have to be updating in your employee handbook. So we'll talk about the California Family Rights Act, or called CFRA. We'll talk about a new criminalization of wage theft. And I will show you a form that when I do audits, 90% of the time I never see it, and it's been in effect since 2011. So we'll share that with you. I'll talk about, do a reminder about CalSavers and some changes to the business COVID-19 requirements. And then we'll take a look at a couple of things that are on the horizon. So right now, the state of the workplace in regards to unemployment has drastically improved. Last year at this time, excuse me, in 2020 at this time, we had 25% unemployment in our state, and we had 4.6 million people that had filed unemployment claims. And at this time, we're down to 394,000 people. So that's been a significant decline. However, there's some industries that are saying, you know, we can't find workers anywhere, such as the restaurant and retail industries. So, but things are improving, and we're glad to see that. And, you know, I hope that these are improving in your businesses as well. So let's start off with the California Family Rights Act. Now, this has been something that's been in our state for quite a few years, but they made some changes this last year in regards to how many employees you have to qualify or be required to give this. So what it is, it's if eligible employees can take up to 12 weeks of California Family Rights Act leave to care for their own serious condition or care for certain family members with serious conditions, or to bond with their new child. So if it was a birth, adoption, or a foster placement. Okay. And during this time, because we say they can take up to 12 weeks, don't worry, you don't have to pay them. They can possibly get paid through the EDD for disability or for family leave. But you do have to hold their position open with similar conditions. So if they were, you know, a server or a cook, or, you know, in retail or whatever industry you're in, you would have to hold their position with similar hours and pay for that 12 weeks. Also, they added in January of this year that it covers family members that are taking care of military active duty employees, I guess, the people that are military active duty. So before that wasn't covered, but they now have covered that. So it could be employees, spouses, domestic partner, child, or parent in the armed forces. So previously, this law only covered companies that had 50 or more employees. So it was for the kind of what we call, they're still small businesses, but that's a hefty payroll to have 50 people. But now they've moved it down to 5 or more employees. So this is going to impact a lot more employers throughout the state. And for an employee to be eligible, they had to meet 3 requirements. One is they have to have worked for the employer for more than 12 months, and they have to have worked at least 1,250 hours in that 12-month period prior to the leave. Now, before it said you had 50 employees, and those 50 employees had to be within 75 miles. So they've taken that orange part that I have highlighted, the 75 miles and the 50 employees out. And now it is only going to be employers that have, anyone that has 5 employees or more. So if you haven't put this in your employee handbook, or you had it in here different from when you were a larger employer, you need to make sure you have these things updated. So here's who's going to be covered for the family members. So it'll cover spouse, domestic partner, and that's ones that are registered only, not just like somebody that's a boyfriend or girlfriend they're living with. Parents, minor child, or dependent adult child. So they added the dependent adult child before it was just a child. And they also included here in January, a child of a domestic partner, a grandparent, grandchild, in-laws, or siblings. In-laws was one of the newer ones as well, because we're seeing more blended families where people's parents, my generation's parents, are moving in and we're taking care of them. Also, there was a change before. If you had two parents that worked in the same workplace, only one of them could take the 12 weeks. Now they're saying each parent is entitled up to 12 weeks of leave. So they could take it concurrently, or they could take it separately for 12 for one parent, 12 for the other. And prior, also, if you were a very high paid employee, like in the top 10% of your position, or like say you were the area manager or someone that only you were doing the job, you were exempt from this, and now you are not. So yeah, so that kind of opened it up to a few more people that were previously excluded. Also, may an employer require medical certification? And the answer is yes. So you can request them to, there's paperwork that they need to fill out where they take it to their doctor. There's called a medical certification. They take it to their doctor they have an application as well that they need to fill out to request the Family Rights Act. And they have to bring that back to you, and the doctor will generally say how long they estimate their time out. If for some reason, like they don't come back by that 12 weeks, before you terminate them, you need to first do like an interactive process and find out what the reason is that they're not coming back. Because there may be an issue that you have to comply with some ADA, American Disability Act. So that there possibility that could be extended a little bit more. And your California Rights Act can run concurrently with your Family Leave Act. So the forms that you usually will use will have both California Family Rights Act and the federal one combined. If you don't put them out on both at the same time, they could use all of one and then start over and use the one for the federal. So you always want to combine them. And they also added a new mediation program with this. So if you're a smaller employer between 5 and 19, you can use this mediation program to resolve any disputes you may have over the leave. So that could eliminate you having to go to a court case in regards to the Family Leave Act. Now, I saw in the chat, someone said, can we get a copy of the slides? And I'd be glad to forward those along. So if you have, like I said, in your employee handbook, have something else, you haven't updated these new changes, you'll want to make sure that you do that. Now, here's one of the newest laws that have come out recently. This happened at the beginning of the year. It's called the criminalization of wage theft. So they're making it a felony now if an employee with intention wrongfully fails to pay wages, including tips, in an amount greater than $950 for one employee, or $2,350 in aggregate for 2 to more employees within a 12-month period. They also say that any independent contractors that you use are considered employees for this law, and entitles then entities that hire such contractors are considered employees. So that's quite a change. And it's not really clear from when I was reading through it, like, what happens if you have a bill dispute with any of these people? Is that considered going to fall into this situation or not? So there could be some more clarification on that. But I thought this was quite a eye-opener. They're now going to consider it grand theft. And with that, you have fines and potential imprisonment up to 3 years. So I think this is really important for you to really look at your procedures and what are some of the things that you do. I know working in the restaurant industry and talking with restaurant clients on a daily basis, I am always coming up with things that I'm like, you can't do that. So here are some things that could possibly put you in violation if you knowingly do not split tips in the tip jar, or the owners keep a portion of it. Owners aren't allowed to keep tips. And if you're if you don't have the system set up correctly to distribute them, it could cost you some issues here if an employee can prove that you have not paid tips to them. Also, if you don't pay people for their missed breaks, that's also lost wages. So this covers lost wages and any type of benefit. If you fail to pay out a bonus they've already earned. So anytime you have a bonus program and you terminate someone, if they've already completed the time that that was required and met the criteria, that's considered wages. I know several people that have told me they haven't given someone their bonus because they found out, something later, and that could have been falling in this issue now. If you consistently remove overtime from their paycheck, if you charge them for broken things or lost things or waste, those could also be considered wage theft if you're taking it off their paycheck. And if you're not allowing them a benefit that is entitled for them to receive. So this is something that is new. It's just coming out. I overheard a story that someone recently had this happen here in Bakersfield recently. Now, it doesn't require them to pay back the amount that they took or withheld. That can be followed up through civil action, but they will be criminally penalized. All right. And here's the one that I was talking about, the Wage Theft Protection Act of 2011. This is one that when I do audits, I never see this notice. And what it requires is that employers provide each employee with a written notice containing specified information at the time of hire. So what we're doing here is they're giving the employee all the contact information for the employer, their wages, and when they'll be paid, also information on sick leave and their workers' compensation carrier. So those are all things that involve wage and payment. And, it's very frequent when I ask people about sick leave, they'll be like, they look at me with like doe eyes, like I've never heard of that before. And then I know for sure that this hasn't been passed out. So I'm going to go to this site here and I'm going to show you what this form looks like. It's called the Notice to Employee, and we'll put a link up for this into the chat. So on this form, you're supposed to give it to them within 7 days of hire, and you're going to put in your company, the employee name first and their start date, and then your legal name of the company. So like your LLC name, if you have an LLC. If you have a DBA, you'll put that here in the second line. And you'll put the address of the hiring employer's main office. So if it's your business, if you have just a brick and mortar location, that's probably what you'll put down. If you have a different mailing address, you'll put that down. If the hiring employer is a staffing agency, they'll fill out this information here because sometimes people do hire people through staffing agencies. And then the next section covers the wages. So you're required to put down their rate of pay and then also calculate what their rate of pay is for overtime, which is 1.5 times the regular pay. You'll mark if they're hourly, shiftly, day, week, salary, piece rate, or commission. And if you do mark that they're on commission as well, you're going to have a written commission policy. And then does the written agreement exist providing the rates of pay? If you do, like give conditional job offer letters or have a commission policy, you need to make sure you mark that off. And then if there's any allowances, if there are any allowances claimed as part of minimum wage, such as meal or lodging, you would list that here. And then you would list the regular payday. On the second part of the form, you have to put in your workers' compensation information. So you'll get this from your insurer. They'll send this out to you and you'll put that information here. Plus, this is the same information that you're required to put on the poster that you have out in the break area, your like multi-law poster for California that goes through the workers' comp. They should have the same information there. So if you have a tendency to change your worker compensation companies out on an annual basis, you'll need to make sure that this is given to the employees on an annual basis as well, within 7 days of that happening. And then in the next section, it goes through the paid sick leave. So this one says they're eligible to use up to 3 days or 24 hours of accrued paid sick leave. So this one is the state. You may have to check your local jurisdiction to see if your city may have a more stringent policy. Like here in Los Angeles, it's six days or 48 hours. And then it kind of talks about their rights, like they can't be terminated or retaliated against for trying to use their accrued sick leave. And it talks about the right to file a complaint against an employer who retaliates. So it's kind of like almost like it tells the employees what they can do if things, if you guys don't follow the rules. So you really need to make sure you know what your sick leave policy is and that you allow people to use it. And then at the bottom, there's a place for the company representative to sign and date and one for the employee to sign and date. And you need to get a copy of it and keep it handy and give them a copy. And then anytime if you do anything regarding their wage, you're going to go back and make the change. So you can either reissue this form again, or you can write them an email, whichever one you prefer. Okay. So I see some questions coming in. Let me see here. I think I'm going to hold them till the end. So let's go back over here so I can make sure I get through all the material. So, so we have the link here. We'll put that in the chat if you still need that. There was also a new law came about talking about the retention of employee records. So previously you were required to maintain personal records for 2 years. Now they have extended it out to 4 years. And if you are in litigation with someone, they're requiring you to maintain those records till the statute of limitations is run or until the conclusion of the litigation, whichever occurs later. So you will have to keep those records a little bit longer in that case. Also, CalSavers is coming up. I think you guys, we've done a couple of these notifications on the Wednesday calls previously, but time is running out. June 30th, 2022 is the last date for employer enrollment. So any company with 5 or more employees needs to sign up their company so that the plan can be administered. Also, independent contractors or 1099ers, you can also sign up if you'd like to participate in a retirement program. Employees that are going to be eligible are employees that are employed in the state of California. They're at least 18 years or older, and they must have a social security number or an I-10 number if they're not a citizen. And sole proprietors or partners in the business may also participate in the retirement program if you'd like. So you either have to have a retirement program of your own, or you can use this state program. And you're not required to do any employee match or anything like that. This whole policy was put into place because they see in the state of California that people are going to be undercovered, and we always are hearing things about maybe Social Security going away. So they want to make sure people are prepared for that. So all you have to do is go to calsavers.com, enroll your company, then they will ask you for the names of your employees, and they will then administer it. They'll send out all the information to the employees, and the employees will be able to either opt in. They're automatically opt-in. So if they don't respond at all to the letters that come automatically, I think it's 5% are going to be taken out of their check. but they can send a letter in and opt out and not have any money taken out. They can also increase the amount if they'd like to have deducted from their paycheck. So every time you have new people employed, you have to send in their names within 30 days so that they can enroll. So the penalty, if you don't sign up for the program, is going to be $250 per employee. And for the first 90 days after this June 20, so that'd be like by September 30. If you haven't done it by then, it'll be a $250 fine. And then another 90 days after that, it'll increase up to $500. So the cost to be in the program doesn't cost you anything. However, some of the payroll companies will charge you a service fee for setting up the deductions and things. So you can always look into that. A lot of insurance companies and things are contacting employers, trying to get them to sign up for their retirement programs. Sometimes I'm hearing employers are, feeling that they're required to do matches, and that's not the case. But CalSavers is really great. You can visit there and they'll be able to answer all your questions for you. Okay, the next part, we're going to talk about some of the COVID prevention emergency temporary standards. So these are the rules for businesses right now during COVID. And there have been quite a few changes there as situations have improved. So previously, unvaccinated people were required to wear masks, but now they're saying that they're not required to wear masks indoors anymore. So really the mask mandate for employers has been lifted. There was a question last week, though. I think someone said, well, can I require my employees not to wear the masks? Because they felt that it wasn't as friendly in hospitality, I guess, with their employees wearing the mask. You're required to provide masks if free of charge if they want to wear a mask. I would highly discourage from telling people they can't wear a mask at work, because everyone has their own individual safety there. And if for some reason, you said they couldn't wear a mask and they could come back and prove perhaps that they caught the illness at work, it could possibly move into a workers' compensation issue. So I still, when I go out, I see people, some employees wearing them, some employees not. There are certain industries still, like the prison, daycares, adult child cares, shelters, they are still required to wear masks. All employees with symptoms must be supplied a free test. This can also be one of the individual ones that, you do your own rapid test. Those are fine. And those can also be used when people come back to show that their tests are okay, but they do need to be like a photograph of it and time stamped. And regardless of vaccination status now, employees who test positive can return to work after 5 days if the employee has a negative test and symptoms are improving, and they wear a face covering for an additional 5 days. So otherwise, the standard is that they will return to work after 10 days. So you have that option to come back a little bit earlier. It's not really clear if we can force them to come back after the 5 days and make them, and if we need them because we're short-staffed. It's going to really depend a lot upon, what their symptoms are. The rule now is you don't have to have partitions and barriers. They're no longer required. However, I've seen a lot of businesses still maintain those. And you must also notify employees if they've been in close contact with someone who has tested positive within 24 hours. So we've seen a lot of people where employers have been notified that someone's tested positive, And the employers have been keeping it very private and only like isolating that one person and not other people that have come in close contact. You want to make sure that that's not the policy that you're following. You're supposed to be notifying everyone that's come in contact more than 15 minutes in a 24-hour period. And all of those people should be tested, and any of them that come back that haven't that come back negative, they can be allowed to come back to work. Now, if you're a larger employer and you have at least 26 employees, then you're also, there's a what they call the COVID-19 supplemental paid sick leave. Now, this actually has been in place in some form since the beginning of COVID back in March of 2020. This new one here is going to end in September 30th of 2022. We'll see if it gets extended or not. It's been extended multiple times, so we'll have to see what the governor decides to do. But what this does, it provides covered employees up to 80 hours of COVID-19 related paid sick leave, with up to 40 of those hours for isolation and quarantine if they're receiving vaccines and caring for a child whose school or place of care is closed, and then additional 40 hours availability if they have to take care of immediate family or someone that lives in their immediate household that has tested positive for COVID-19. Now, all of this money is paid not by you as the employer. There's actually you can request this through your IRS. So when you're like doing your 941s, you can put this under the paid sick leave and you'll be reimbursed for that. If you don't have enough money to pay these wages at the time, you can also fill out IRS form 7,500 and request those monies ahead of time. So there's been some tracking of this, and they have found that at least 25% of the people that qualify for this have not been getting any type of support with this supplemental paid sick leave. So I just wanted to make sure that everyone is aware of it. It's not something that's going to come directly out of your pocket to pay. You'll be reimbursed for this. Okay. And I wanted to share a couple things that are showing up here in the state of California that we need to keep a close eye on. And one of them hit the news recently, just a week or so ago. 4 stores here in California for Starbucks voted to unionize. So 2 in Santa Cruz and 1 in Long Beach and 1 in Lakewood. That brings up to about 74 Starbucks that have now unionized throughout the country. There's 22 other petitions that have been filed for further unionization here in the state of California. And, of course, they see what happens and they look to see, and people will start adding more and more on. It's not good news for Starbucks. It's going to make it much more difficult for them to manage, and it'll be much more costly. The person that's leading it, his name is Jay Thompson. He is also running for the State Assembly District 28, which is in the Silicon Valley. So, everyone in the restaurant industry is really like looking at this, and I would be with any industry concerned, because when we see unionization come, in some aspects it can be good for the employee, in some aspects it can be difficult for the employers as well. So I would always be looking and reading up on, unionization prevention, and generally it's having good business practices and taking care of your employees. And a lot of times we'll hear in these complaints by the employees that sway the voting is that, their bosses are not engaged, or they treat them unfairly or inconsistently. They don't pay fairly or use the California labor laws correctly. So a lot of, we're going to see a lot more of this, particularly as employees are feeling the pressure as well with rising inflation costs. And then lastly, on the restaurant end of it, there is a law called the Fast Accountability Standards Recovery Act that's putting the chill in franchise types organizations. It's AB 257. It's already passed the Assembly and is now going to the Senate. But what this would do is it puts employees and union proponents on a board that will set wages for the industry. And it'll also legislate that franchisors and franchisees are joint employers. So the sins of the franchisees will be held against the franchisors. And that's one thing the franchisors have always said, that we're separate entire companies, and we're not responsible. But that if this passes, that could be the change. This board that's going to be created will have 11 members. 2 will be employees. There'll be some labor proponents on there, and they're going to have the authority to draft state labor standards for fast food restaurants. And also they'll be able to look at occupational safety as well as wage and work time rules. So I'm sure that that people are trembling over this. It had gone to the state assembly twice and it passed the second time. What I find, like working with like the California Restaurant Association or other business associations, what often happens is things like this will go to the state level, and if they don't pass, then they just start the lobbying and putting the ballots on local jurisdictions where people are less likely to pay attention to. And so if they don't get them statewide, they'll get them into metropolitan areas and other places where people aren't paying enough attention to what's on the ballots and things like that. So those are all the things that I brought to share with you today. I think we have some time for questions for sure. Here's my contact information as well if you need any assistance. If you're being serviced here by our SBDC, you can make appointments with me as well. And if you have any questions, you can always send me an email and I'll be glad to contact you. So let's go to our chat and questions, I guess. Did you want to read the questions to me, Kelly, or would you just like me to go through them? Let's see here. You're muted, by the way.
Yes, you've done a fantastic job so far. Go ahead and read them, and then we'll go through the chat together.
Okay, so we have 2 questions. Why is the company's unemployment reserve account being reduced by claims due to COVID shutdowns and state mandated issues? That's a very good question, and I really don't have the answer for that. I was under the impression that it wasn't, but being that you're asking this question, you may have been impacted. So Holly, if you'd like, you can always do a private message with me in the chat with your email, and I'll be glad to investigate it for you. Because sometimes HR is kind of broad and I can't know all the questions that do come up, but that is a very good point because most everyone was affected by that. But I had read early on that they weren't going to be charging that. Okay, Diana, if an employer has less than 26 employees, but pays its employees this type of sick pay, can this employer still be reimbursed? No, it can only be if the government will only reimburse you for if you have 26 or more. And the employees can use their regular paid sick leave, their state sick leave as well during this time. So if they have any accrued sick leave, they can also use it for that time. Good question. Okay, so let's see. I see, when is LC 28105 form required to be used? I believe the form number you're talking about there is that notice to employee. That's supposed to be given to them, the wage protection one, when they're hired. So you have to give it to them within 7 days of being hired, or if there are a change a wage or workers' compensation carrier. Anytime there's any information changes on that form, you have to update. So maybe if you even change your mailing address, you have to make sure they're updated. CalSavers, I have 5 part-time employees. Yeah, you would still need to apply for CalSavers. So the process for you signing up will be very, very short. It's just a very quick application process. And then they'll take care of all the rest of the administration. They'll send out the notices to the employees. The employees will have to send back and opt in or opt out. I would highly recommend, like sometimes I'll hear employers say, well, they'll send things back for the employee. I would totally keep my hands out of that whole transaction, because what happens if, say, you don't send it in, and then later they say, oh, they didn't give me the option. So you want to let the CalSavers or whatever company that you're going to use to do your retirement plan be the main contact with those people. Great question. Okay, let's see. Okay. Is it possible to sign up if employees total is less than 5? Yes, anyone can sign up if they'd like to, and you as an employer as well, you can sign up if you'd like to participate in the program. They just have to be over 18 years old, and you have to be working in the state of California. Okay, if all employees are also members of the corporation, is this form required? Oh, the form for the notice. I would provide it to everyone that's an employee. So like if you're an S Corp, I'd still do the document for yourself. Because one of the things is, like, when we run into PAGA lawsuits, the Private Attorney General's Act, where they go back and they start looking at whether you're following labor laws. You just don't want to have anything where they can have any problem there. I guess we're getting down to our time, aren't we? Available in Spanish, this form. I'm sure we can probably get a copy of it in Spanish. Jessica, if you send me your email, I'll be glad to see if I can find it and I'll send it to you. And if you haven't already provided it, now's the time. You can provide the form and get straight with it now. It's no problem. Okay, well, I think that's all our questions. Thank you so much, guys, for participating.
I think you nailed them all.
Thank you.
Just in the chat are a few other resources that you'll find. You'll find information on the Dream Fund, also the Kern County Micro Business Grant Program. So those resources are in there, and the Family Rights Act for the state of California, and a lot of other resources. So Celeste, yeah. Great to have you on again. And I did fail to mention that, if you are new to the SBDC and want to meet with Celeste, you can sign up as a client and we can hook you up for an appointment with Celeste. Celeste prefers phone or Zoom appointments. And if you are an existing business, like we've had a few of you that have asked questions today, an existing business who is already a client of the SBDC, we can pass you right along to Celeste. So great resource. Thank you so much, Celeste.
Thank you, Kelly.
So that does bring us up to the end of our hour plus a minute. So for Celeste Young-Ramos, I'm Kelly Bearden. We'll be back next week with number 115 next Wednesday at noon. Thank you so much, everybody. Have a great week. Bye-bye now.